the only active federal lawsuit challenging California's ban on Glock and Glock-style handguns has been frozen. On March 27th, both sides in Jaymes v. Bonta filed a joint motion to stay all proceedings. The court granted it the same day. All deadlines have been vacated. A joint status report is due within 90 days. And as of right now, there is no active litigation standing between AB 1127 and its full enforcement date of July 1st. AB 1127 was signed by California's governor on October 10, 2025. The law targets semi-automatic pistols equipped with a cruciform trigger bar, an internal component found in every Glock model and in several other manufacturers' handguns listed on California's roster, including models from Shadow Systems. The stated justification is to prevent handguns that can be readily converted into machine guns using aftermarket switch devices. Federal law already bans those conversion devices. AB 1127 goes further by banning the sale of the handguns themselves at the dealer level. The law rolled out in two phases. Phase 1 took effect January 1st of this year, restricting when dealers could acquire new inventory of affected models. Phase 2, the full prohibition on dealer sales of these pistols, takes effect July 1st. After that date, no licensed dealer in California will be able to sell a newly restricted Glock-style handgun to a member of the public. Ownership of firearms already legally purchased remains lawful, but no new sales of affected models through licensed dealers will be permitted. Within days of the law being signed, a coalition including the NRA, Firearms Policy Coalition, and Second Amendment Foundation filed Jaymes v. Bonta in the U.S. District Court for the Southern District of California. The case was eventually assigned to Judge Gonzalo P. Curiel after the originally assigned judge recused. The complaint challenged the constitutionality of banning an entire class of commonly owned handguns, arguing that Glock pistols, specifically the Gen 3 models that had made up a substantial share of California's shrinking handgun roster, are protected under the Second Amendment. The lawsuit relied heavily on a specific factual premise that AB 1127 effectively removed an entire category of handguns California residents had been legally purchasing and relying on for decades. For a time, that argument had real force, but then the ground shifted underneath the case. Before the law even reached its full enforcement date, the manufacturer stopped producing the models the lawsuit was built around. Reports began circulating in late 2025 that Glock was phasing out its Gen 3, Gen 4, and Gen 5 pistols. By the end of November 2025, Glock had confirmed that legacy production was ending. In January of this year, the company officially launched its Gen 6 line, which is now the only generation in production. That move had a direct impact on this litigation. The core of Jaymes v. Bonta was that AB 1127 banned all Glock handguns available to California buyers. With the manufacturer itself discontinuing those models, the practical question becomes what exactly the lawsuit is fighting to restore. AB 1127 does contain a provision that would allow previously roster-listed manufacturers to reapply with new models by December 31st of this year, potentially without meeting every standard roster requirement. Whether Glock intends to submit a Gen 6 model under that provision has not been publicly confirmed. That factual shift appears to be closely connected to what happened on March 27th. On that date, all plaintiffs and the defendant jointly asked the court to stay the entire case. The court granted the motion the same day, vacating all scheduling deadlines, including the status conference that had been set for today, April 3rd. The parties now have 90 days to file a joint status report. The court's order is short and procedural. It does not dismiss the case. It does not declare the case moot. It does not resolve any constitutional question. It presses pause on every aspect of the litigation. And because this was a joint motion, meaning both sides agreed to it, the stay was not the result of a contested fight. Federal litigation proceedings are stayed for a variety of reasons. Sometimes the parties are negotiating. Sometimes they are waiting for a separate legal development that could affect the outcome. Sometimes the factual basis of the case has shifted enough that the plaintiffs need to reassess. The public record does not tell us which of those applies here, but the timing and context make the factual shift around Glock's product decisions difficult to set aside. AB 1127 does not only affect Glock. Shadow Systems had multiple roster-listed models with cruciform trigger bars. Other manufacturers are potentially affected as well. The law's reach extends beyond a single brand, but Jaymes v. Bonta was built around the argument that this law wiped out the most widely purchased handgun platform in the state, and when that platform was voluntarily pulled from production by the manufacturer, the litigation posture changed. There is a real possibility, and this is analysis rather than confirmation, that the plaintiffs may ultimately be unable to continue pressing the case as originally framed. If the specific handguns at the center of the complaint are no longer in production and no longer being offered for sale through the roster, the standing and mootness questions become significantly more complicated. If you have been following Thomas updates through March, you already know that California's firearms regulatory environment has been moving on multiple fronts simultaneously. We covered AB 1078, the 3-per-month purchase cap that went into effect on April 1st, along with SB 948, the proposed 8-hour mandatory training requirement that cleared its first committee hearing on March 17th. Road v. Bonta, the ammunition background check challenge, went before the full Ninth Circuit and Bonk panel in Pasadena on March 25th. All of those breakdowns are already on the channel for anyone who wants the full detail. Jaymes v. Bonta was, until this week, one of the most prominent active challenges to a California firearms law. With the litigation now frozen and no clear timeline for when or whether it resumes, one of the most visible legal vehicles in the state has gone quiet. The broader fight over California's handgun restrictions has not gone quiet, though. On March 27th, the same day the stay was granted in Jaymes, a motion was filed in a separate case, Rena v. Bonta, to add the NRA as a plaintiff. Rena is a direct challenge to California's entire handgun roster system. The complaint argues that the roster itself violates the Second and 14th Amendments by banning the vast majority of handgun models commercially available in the rest of the country. That case has been working through the court since 2020, and a preliminary injunction ruling is currently on appeal before the Ninth Circuit. So while the specific Glock ban challenge in Jaymes has stalled, the broader constitutional question about which handguns California can prohibit remains active through a different legal vehicle. If you want to stay current on these developments, subscribe to Thomas Updates. When the 90-day status report lands, or if Rena v. Bonta produces a ruling that reshapes this area of law, the update will be here. As of tonight, AB 1127 is in force. Phase 2 takes effect July 1st. The only lawsuit directly challenging that law is stayed, with all deadlines vacated and a status report due within 90 days. The manufacturer whose products were at the heart of the case has discontinued the models in question. A separate and broader challenge to California's entire handgun roster is still active and has just added a major new plaintiff. The constitutional questions underlying both cases remain unresolved. Everything covered here is drawn from public court filings, official docket records, and legislative materials, and reflects my own analysis of those sources. This is informational and educational content, not legal advice. If AB 1127 or any California firearms law directly affects a decision you are facing, The right step is to speak with a licensed attorney in your jurisdiction.